Murkowski.
Can I have the rest of Senator Hickenlooper's
Yes,
time
you
here?
can.
Thank you. I appreciate that. Right. I might just follow on what the senator has pointed to in terms of the collaboration that can go on. I had an opportunity to visit the reopening of Resurrection Creek near Hope, Alaska, about a month or so ago. This was a collaboration between Trout Unlimited and Kinross Gold. It's really encouraging to see industry partnering with the conservation groups. I said if the mining industry and conservation can come together, then quite possibly Democrats and Republicans can, although that's looking a little more sketchy nowadays, but I thought it was a good example. Mr. Chairman, I want to thank you for having this hearing today, and Senator Cortez Masto for encouraging it. This is where these conversations should happen. It should not be happening in a reconciliation bill on the House side or on any side where you just kind of shove something in and hope we get it right. The fact that this mining law has been around since 1872 kind of says something. But I think what we've heard today is nobody's afraid to be talking about what we might want to do to make things better, as long as we make things better rather than trying to thwart and to kill an industry that has been an extraordinary job creator and really a source of economic strength for our country. But we know we can go exactly the other way if we do things wrong and we do things in a manner that is not thoughtful. And I think what we've heard today is that to take an 8% gross royalty for hard rock production, a reclamation fee of 7 cents per ton, and a claim maintenance fee, these are going to take us in the wrong way. So let's talk about ways that we can, again, make sure that we are doing the right things in the right way. My goal, my mission here when it comes to mining is it's a commitment towards working towards reform that are going to provide the industry with the regulatory certainty that it needs, because we know that that is important for making investments, provide a fair return to the public for mining activities on our public lands, protect the environment, ensure this industry, which again has historically had some of the highest paying jobs in their region, but also to provide these building blocks that we need for renewable technologies and to have a future here. So I appreciate this conversation. I really appreciated, Mr. Haddock, what you had outlined in terms of just the steps that go into a hard rock mining production and why it's different every single step of the way in terms of how you get from the beginning of a project to the time where you're actually putting some product out there into the market. I think these are the types of discussion that we need to have. I want to turn my question to you, Ms. Sweeney, and this relates to the reclamation fee. I'm actually kind of curious about this proposal because this is not the first time that it's come up. It came up during the Obama administration. The EPA went through a pretty rigorous exercise to determine whether the hard rock mining industry should be covered under CERCLA. After a pretty lengthy process, they decided not to promulgate final regs because, and these are their words, they were unnecessary and would therefore impose an undue burden on the regulated community. And then they said that the proposed requirements would be disruptive to state mining programs. So if you have an administration that had taken a look at this and determined that this was going to not be necessary because it places an undue burden, how is this fee that is being proposed now, the 7 cents per ton, any different than what was looked at under the Obama administration?
I don't really think that it is different, and thank you for all the work that you did on the EPA financial assurance rulemaking and working with the industry to make sure that those kind of fees weren't imposed. But the dirt tax, you know, it also is not a solution to abandoned mine land creation. We have modern regulations in place today that protect our lands and the environment, and there's also over $6 billion worth of financial assurance held to fulfill those reclamation requirements in case operators are not able to
So let
do
me ask about that, because within Alaska, our Department of Natural Resources and BLM, they've got cooperative agreements to co-administer a bond pool that companies then pay into. And under Alaska law, we require that a reclamation plan be approved before the operation can be commenced. They review the amounts every 5 years, and then if the operator faces hardship or can't do the cleanup, the agencies first reach out to the industry. But every time this has happened, I'm told, the industry has stepped up with the expertise, the equipment, the labor, and more to do the cleanup to the agency's specifications. So as a result of the cooperation that we've seen, the bond pool has never needed to be called on in Alaska to perform cleanup. So I'm looking at this and wondering if there is an additional reclamation fee of the 7 cents. Is there a concern that this additional tax could undercut the willingness of companies then to step up on a voluntary reclamation efforts if they're already going to be forced to be paying more? What happens to what we already have in place if you do this overlay?
That is a really interesting question that I have not thought about, but I would think that our companies still want to do the right thing and be helpful and clean up the environment. But will the companies be here in the United States anymore if they're paying those kinds of fees?
Fair enough. Mr. Chairman, my time is up. I do have a lot more questions that I'll submit for the record, but I appreciate the comments from everyone here today.